As of this morning, the rules for living and working in California have fundamentally shifted. Hundreds of new laws just went into effect, and they are already touching everything from your monthly paycheck to the food in your child's lunchbox. Whether you're a renter demanding a working fridge, a worker trapped in a training debt, or a student facing a phone-free classroom, these changes are no longer theoretical. They are the law of the land. This update breaks down 10 massive shifts that are legally enforceable right now, ensuring you stay protected in this new 2026 landscape. Number 1. The Digital Wall, AI Professionalism, AB 489. Interacting with a medical support line late at night often brings quick and confident advice, but patients frequently wonder if they are speaking to a person or an algorithm. Starting today, California law AB 489 makes it illegal for AI chatbots to pose as licensed professionals, such as doctors or nurses. This regulation ensures that developers cannot use deceptive design elements or titles to create a false sense of clinical authority. Scientific studies regarding human-computer interaction suggest that individuals calibrate their levels of certainty differently when they recognize they are speaking with a machine. The new legislation mandates explicit disclaimers and requires that human-in-the-loop options remain available whenever automated tools provide health or legal guidance. It aims to protect the sanctity of professional judgment by ensuring that empathy-driven care remains clearly distinguishable from machine-generated data. Practical changes are already appearing in digital interfaces across the state as companies scrub their marketing of terms like doctor-level or clinician-guided unless a human is directly involved. If you access a health app today, you will likely notice new transparency markers or pop-up notifications identifying the AI's identity. These safeguards prevent the subtle manipulation of users who might otherwise follow medical advice without knowing it originated from a non-human source. This shift places California at the forefront of ethical technology, prioritizing user clarity over corporate automation in high-stakes environments.
Number 2. The 1690 Shift, Minimum Wage 2026. The cost of living in the Golden State has triggered yet another mandatory adjustment for the workforce this morning. As of January 1, 2026, the California minimum wage has officially climbed to $16.90 per hour for all employers, regardless of their total staff count. This increase is part of a multi-year effort to align local earnings with the National Consumer Price Index, ensuring that purchasing power does not vanish under the pressure of rising inflation. While the hourly bump appears modest on the surface, its legal ripple effects across various sectors are profound and immediate. Economic research regarding efficiency wages suggests that higher base pay often leads to reduced turnover and increased worker commitment, which can actually stabilize business operations over the long term. However, the most significant impact of this law is often hidden within salaried positions rather than hourly roles. Because the legal test for exempt status in California is strictly tied to the state minimum wage, the floor for administrative and executive salaries has moved. This means that to remain exempt from overtime, an employee must now earn a minimum annual salary of $70,304. If you are a professional or manager currently earning less than this new threshold, your employer is now legally required to pay you overtime rates for any work exceeding 8 hours a day. Many workers may find their classification shifting today as companies struggle to meet these updated financial requirements. It is essential to review your next pay stub for any adjustments in your base pay or your classification status. This legislation ensures that the title of manager cannot be used as a loophole to avoid paying employees for the actual hours they contribute to the economy.
Number 3. The Phone-Free School Act, AB 3216. Walking into a California middle school today reveals a striking visual shift. Students are looking at one another rather than at glowing rectangles. The Phone-Free School Act has reached its final implementation phase, requiring every school district, charter school, and county office of education to adopt policies that significantly limit or prohibit smartphone use during the instructional day. This law responds to growing alarms from educators who have witnessed classrooms transformed into digital hubs where social media notifications take precedence over academic engagement. By July 1, 2026, every public campus must have these restrictive measures fully active to ensure a uniform learning environment across the state. Scientific research from the American Psychological Association and various educational studies highlight that even the mere presence of a smartphone on a desk reduces cognitive capacity and focus. When students are constantly tethered to their devices, they experience higher rates of anxiety and a phenomenon known as fear of missing out, which fragments their attention during critical lessons. The removal of these devices is expected to boost test scores and reclaim thousands of hours previously lost to mindless scrolling. Furthermore, school administrators report that these bans are essential for curbing cyberbullying and unauthorized recordings, which often occur in the privacy of hallways or locker rooms. Practical application of this law varies by district, with many schools choosing to utilize magnetic pouches or designated phone lockers to store devices from the first bell to the last. Parents should note that the law does include specific exceptions for students with documented health needs or during genuine emergency situations where communication is vital for safety. Beyond the academic benefits, the state is prioritizing the social-emotional well-being of the younger generation by forcing a return to analog, face-to-face interactions. This cultural pivot aims to nurture a more focused and connected student body that is prepared to engage with the world without the constant filter of a screen. Number 4. The Digital Guardrail, AB 489 and AI Transparency. Imagine accessing a medical support line late at night and receiving advice that sounds incredibly confident, yet you start to wonder if the responder is a person or an algorithm. As of today, California law AB 489 has officially shifted the landscape of digital healthcare by making it illegal for AI chatbots to pose as licensed professionals. This includes instances where automated systems might attempt to impersonate doctors, nurses, or mental health counselors without clear disclosure. This legislation is a direct response to the rapid integration of large language models into patient-facing interfaces, ensuring that users are never misled about the source of their medical guidance. Scientific studies regarding trust calibration show that human beings process information differently when they know the source is artificial, rather than a peer with lived experience. The law requires that any entity using AI for professional services must provide prominent notifications at the start of the interaction. Furthermore, it mandates that human-in-the-loop options remain accessible for high-stakes situations where a machine's logic cannot replace a clinician's empathy or nuanced judgment. By enforcing these transparency standards, the state is attempting to prevent algorithmic bias from affecting patient outcomes without the oversight of a human expert. In practice, you will notice that health apps and legal portals now feature unmistakable labels such as AI-generated support or virtual assistant. Companies are also required to audit their systems to ensure they do not offer definitive diagnoses, which remains a protected human professional activity. If a chatbot provides a recommendation, it must now be paired with a disclaimer urging the user to verify the data with a board-certified practitioner. This change prioritizes consumer safety and ensures that the convenience of technology does not come at the expense of professional accountability. This is a bold step toward defining the boundaries of artificial intelligence in our most sensitive personal interactions.
Number 5. The IVF Insurance Mandate, SB 729. Starting today, the journey to parenthood becomes a significantly less daunting financial hurdle for millions of residents. California's Senate Bill 729 has officially taken effect, requiring large group, fully insured health plans to provide coverage for the diagnosis and treatment of infertility, including in vitro fertilization, IVF. Previously, insurers were only required to offer this coverage to employers, who frequently declined it to save on premiums, leaving patients to face out-of-pocket costs, often exceeding $20,000 per cycle.
This landmark mandate finally categorizes infertility as a medical condition that deserves the same level of insurance support as any other disease or physical ailment. Medical research from the American Society for Reproductive Medicine indicates that financial stress is one of the leading barriers to successful fertility outcomes, often forcing couples to choose less effective treatments or risky multiple embryo transfers. By removing the cost barrier, the law encourages safer clinical practices, such as single embryo transfers, which drastically reduce the likelihood of high-risk multiple births and neonatal complications. Furthermore, the legislation redefines infertility to be more inclusive, specifically eliminating old requirements that effectively barred LGBTQ+ individuals and single parents by choice from accessing these benefits. This shift ensures that family building is treated as a fundamental right rather than a privilege reserved for those with immense personal wealth. Practical implementation of SB 729 means that qualifying plans must now cover up to 3 completed egg retrievals and unlimited embryo transfers. It is important to note that this mandate applies to fully insured plans regulated by the state, typically those at companies with 101 or more employees. If you are covered by a self-insured plan or work for a religious employer, you may still face original restrictions, so contacting your Human Resources Department for a summary of benefits is a vital first step. For many, this change represents the difference between a dream and a reality, providing a clear path towards starting a family without the shadow of crushing medical debt. Number 6. Grocery Transparency and Food Safety. AB 1264. California has officially initiated a historic transformation of school nutrition through the Real Food, Healthy Kids Act, also known as AB 1264. This landmark legislation establishes the nation's first statutory definition of ultra-processed foods and mandates their gradual removal from public school cafeterias. By targeting products that are industrially manufactured with chemical modifiers, the state aims to replace shelf-stable synthetic items with fresh, whole food alternatives. Starting this morning, state health agencies have begun the formal process of identifying ultra-processed foods of concern, which includes items high in saturated fats, sodium, and specific non-nutritive sweeteners that have long dominated school breakfast and lunch programs. Scientific data from the California Office of Environmental Health Hazard Assessment suggests that many common additives, specifically petroleum-based dyes like Red 40 and Yellow 5, are linked to adverse neurobehavioral effects in children. Research indicates that these substances can trigger or exacerbate hyperactivity, restlessness, and decreased attention spans, which directly interferes with a student's ability to thrive in a classroom setting. By stripping these hyper-palatable foods from the daily diet of millions of students, California is leveraging nutritional science to support both physical health and cognitive development. This proactive stance recognizes that the quality of food served at school is a primary driver of long-term metabolic health and academic success for the next generation. Practical shifts for families will involve seeing fewer a la carte snacks containing artificial colors and more minimally processed grains, fruits, and vegetables on the daily menu. While the full ban on specific dyes and restricted ingredients will reach critical milestones by December 2027, school districts are already being incentivized to procure locally grown, real food products starting today. Parents can expect to see updated ingredient lists from their school's food service providers as vendors begin their mandatory annual reporting on product composition. This change is not merely about removing junk food, but about fundamentally redesigning the school environment to prioritize nourishing, additive-free meals that provide a stable foundation for learning and growth. Number 7. Renters' Essential Rights. AB 628. For decades, California habitability laws surprisingly treated a working refrigerator as an optional luxury rather than a basic necessity for modern living. That legal oversight ended overnight as AB 628 officially went into effect, reclassifying cold food storage as an essential service on par with running water, heat, and electricity. Under this new mandate, a landlord is now legally required to provide and maintain a functional refrigerator in every residential unit, unless the lease specifically states the tenant is providing their own. This shift acknowledges that in the modern economy, the ability to store fresh food is a fundamental requirement for maintaining a healthy and stable household. Legal and public health researchers have long argued that food deserts are often exacerbated by poor housing conditions, where a lack of reliable appliances leads to an over-reliance on expensive, shelf-stable processed goods. Scientific studies on nutrition highlight that households with access to proper refrigeration consume significantly higher levels of fresh produce and proteins, leading to better long-term metabolic outcomes. By elevating the refrigerator to a mandatory standard of habitability, the state is closing a loophole that previously allowed property owners to ignore broken appliances for weeks at a time. This change provides tenants with a powerful tool to demand immediate repairs, as a non-functioning fridge is now considered a substandard housing condition. Practical application of this law means that if your refrigerator fails, your landlord is now responsible for its repair or replacement within a reasonable time frame, typically considered 24 to 48 hours given the perishability of food. Furthermore, property owners cannot pass the cost of these essential repairs onto the tenant through hidden maintenance fees if the appliance failed due to normal wear and tear. If you are currently renting a unit without a fridge, or if yours is currently broken, you now have the right to file a formal request for habitability upgrade. This legislation represents a massive victory for tenant protections, ensuring that every Californian has the basic infrastructure needed to nourish themselves and their families safely at home. Number 8. Transit-Oriented Housing, SB 79. California has officially entered a new era of urban planning with the activation of Senate Bill 79, known as the Abundant and Affordable Homes Near Transit Act. This landmark legislation effectively overrides local single-family zoning within a half-mile of major transit hubs, such as heavy rail stations and high-frequency bus corridors. By mandating higher density in these transit-rich zones, the state aims to address the acute housing shortage while simultaneously boosting ridership for public transportation systems like BART and LA Metro. Starting today, residential and mixed-use projects that meet specific criteria are considered an allowed use, meaning cities can no longer use restrictive local zoning to block the construction of multi-story apartment buildings in these strategic areas. Environmental studies and urban planning research highlight that transit-oriented development is one of the most effective tools for reducing a state's carbon footprint. By allowing more people to live within walking distance of high-capacity transit, California expects to see a significant decrease in VMT and daily traffic congestion. The law utilizes a tiered system. Tier 1 zones near heavy rail allow for buildings up to 95 feet tall, while Tier 2 zones near light rail or rapid buses support slightly lower heights. Furthermore, SB 79 includes strict anti-displacement protections, prohibiting the demolition of any housing that has been occupied by tenants within the last 7 years. This ensures that new growth does not come at the expense of existing low-income residents. Practical impacts for developers and residents include a streamlined path for projects that dedicate at least 13% of units to lower-income households. This base density boost allows builders to start with a much higher unit count before even applying for additional state density bonuses. For communities, this shift will likely manifest itself as a gradual transformation of underutilized commercial lots and parking structures into vibrant, walkable neighborhoods. While local governments retain some flexibility to propose alternative plans, they must prove that their substitute zoning provides the same net housing capacity as the state mandate. This legislation fundamentally shifts the power dynamic from local obstruction towards statewide housing goals, marking a permanent change in how California's urban landscape will evolve over the coming decade.
Number 9. The End of Stay or Pay Contracts, AB 692.
California has officially dismantled a controversial labor practice today with the enforcement of Assembly Bill 692, which prohibits most stay-or-pay provisions in employment contracts. These clauses, often referred to as training repayment agreement provisions, TRAPs, historically forced workers to reimburse their employers for training, relocation, or onboarding costs if they left their jobs before a specified date. Legislators argued that these financial penalties acted as debt traps, effectively chilling labor mobility and preventing workers from seeking better opportunities. As of this morning, any new contract containing such terms is considered void and contrary to public policy, marking a significant victory for the freedom of the state's workforce to move between jobs without the fear of a surprise invoice. Legal and economic research indicates that these repayment requirements are frequently used as a tool for retention through debt rather than through competitive wages or healthy work environments. By eliminating these quit fees, the state aims to foster a more dynamic labor market where businesses must compete for talent based on merit and workplace quality. The law is comprehensive, banning not only direct training reimbursements, but also any penalties related to replacement hire fees, lost profit claims, or even the costs associated with processing immigration visas. This shift aligns with California's long-standing prohibition on non-compete agreements, further solidifying the state as a jurisdiction that prioritizes worker mobility and competitive fairness over restrictive corporate controls. Practical implications for employees are substantial, as the law establishes a private right of action with a minimum damage floor of $5,000 per violation. While existing agreements signed before today remained grandfathered in, any new hire or contract renewal must now comply with strict transparency standards. There are narrow exceptions for transferable credentials, such as an accredited degree, but these must be offered in a standalone agreement that is not a condition of employment. For most workers, this means that proprietary, company-specific training can no longer be used as a financial anchor. If you are starting a new role today, you are legally protected from being billed for the very skills you were hired to use, ensuring your career path remains entirely under your own control.
Number 10. Third-hand smoke disclosures, AB 455. Purchasing a home in California has always required checking for mold or lead paint, but as of today, buyers must also be warned about the invisible legacy of tobacco. California Assembly Bill 455 officially elevates tobacco and nicotine residue to the same status as other major environmental hazards. The law mandates that sellers of residential properties with 1 to 4 units disclose, in writing, any actual knowledge of past indoor smoking or vaping. This requirement is now a permanent fixture of the Transfer Disclosure Statement, TDS, ensuring that third-hand smoke is no longer a hidden defect. This legislation recognizes that a home's history of tobacco use is a material fact that can impact both the physical health of the occupants and the financial value of the real estate. Scientific research from the Third Hand Smoke Resource Center at San Diego State University reveals that tobacco residue is a complex mixture of gases and particles that embed themselves into walls, carpets, and ventilation systems. These pollutants, including nicotine and carcinogens like NNK, can persist for years and even undergo chemical transformations that increase their toxicity over time. Studies indicate that children are particularly vulnerable because they are more likely to touch contaminated surfaces and ingest dust while playing on the floor. By classifying this residue as an environmental hazard, California is following decades of peer-reviewed evidence showing that simply airing out a room or applying a fresh coat of paint is often insufficient to remove these persistent toxins. For buyers, the practical impact of AB 455 is a significant boost in consumer protection and negotiating power. Once you receive a disclosure indicating a history of indoor smoking, you have a statutory 3-day right to cancel the contract if the notice was delivered in person, or 5 days if sent by mail. This window allows you to conduct specialized professional testing or obtain remediation estimates, which may include the costly removal of carpets and drywall in extreme cases.
Sellers, while not required to perform independent inspections, must be honest about their actual knowledge of smoking activity to avoid future liability for non-disclosure. This law ensures that your new home is a truly fresh start, free of the toxic chemical reservoir left behind by previous occupants.
As we have seen, the legal landscape of California in 2026 is no longer just about incremental changes. It is a total overhaul of how we interact with technology, our workplaces, and our own homes. From the moment you clock in at your new $1690 hourly rate to the moment you step into a home that is now legally required to be transparent about its toxic history, these laws are designed to shift the balance of power back toward the individual. We are seeing a state that is aggressively defining the boundaries of artificial intelligence, mandating that human-in-the-loop protections remain a right rather than a privilege. At the same time, the focus on student well-being through phone-free zones and additive-free meals suggests a long-term commitment to a healthier, more focused next generation. Navigating these shifts requires staying proactive. Whether you are a renter now entitled to a working refrigerator or a worker finally free from the stay-or-pay debt trap, understanding these 10 laws is your first line of defense. The common thread here is transparency. Transparency in what we eat, how we are paid, and who we are talking to online. As these regulations settle into daily life, they will likely set a new national standard for consumer and worker rights. Stay informed. Check your contracts, and know that your rights as a Californian have just become significantly stronger. If you found these updates helpful, hit the like button and subscribe to stay ahead of the curve as more 2026 regulations roll out. Have these new laws impacted your job or your housing situation yet? Drop a comment below and share your experience. Your insight might help someone else navigating these same changes.